The Appellate Division First Department is now in session. Good morning. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar. Please give me your attention as I do so. People versus Andre Graham is submitted. Brioso versus Motor Vehicle is submitted. Edwin E versus Monique A is submitted. Borges versus Rose is submitted. Funkelstein versus the City of New York. For the appellant, Alan Levine.
Present, Your Honor.
4 and 1. For
Yes.
the respondent, Kevin Osowski.
Good morning, Your Honor.
4 minutes. Stevens versus NYSDHR is submitted. People versus Reginald Jones. For the defendant.
Hi, good morning.
Good morning, John Palmer.
Yes.
5 and 1. For the respondent.
Yes, this is John Hughes for the people.
John Hughes, 5 minutes.
Thank you, Your Honor.
China Privatization versus Galaxy Entertainment. For the appellant, Jacob Buckdahl. Is that right?
It's Bookdahl, I always say.
Buckdahl. Well, if you say it, must be right. Booked on that point.
Good morning, Your Honor.
Buckdahl. Good morning. 7 and 1.
Let's make it, if you don't mind, let's make it 5 and 3.
5 and 3. And for the respondent, Daniel Katz, 8 minutes.
Good morning, Your Honor. Robert Schrager from Tucker Latifi. I'm the New York attorney. If I may, I'd like to introduce my colleague, Daniel Katz from Williams and Conley.
Okay, and you're asking, obviously, that he be admitted pro hoc vice.
Yes,
and you
I
made
am,
that
Your Honor.
motion prior.
Yes, and we have the letter. It was submitted to the...
And I will permit it. I'll grant that. 8
Thank
minutes.
you, Your Honor.
Thank you.
People versus Edwin Baez.
Claudia Troop for the appellant.
That's 5 and 1. And for the respondent, Lee Pollock for the people.
Yeah. Well,
Lee
Ellen
Pollock.
Friedman, Your Honor.
I beg your pardon?
My name is Ellen Friedman. I submitted the notice of appearance. Lee's no longer with our office.
Ellen Friedman, 5 minutes.
Thank you, Your Honor.
Safeco Insurance versus Pilat is submitted. Aru versus Rosenfeld, submitted. People versus David Owens is submitted. People versus Paul Manafort. For the people, I believe it's Valerie Figueroa. Is that right?
That's correct, Your Honor.
And that's 6 and 2. And for the defendant, Todd Blanche. Is that correct?
Yes, Your Honor,
7.
that's correct. Here.
7 minutes. Senera versus Bedford Webster. For
Good morning, Your Honor.
Good morning. This is a cross appeal. 3170 and Joy. Would you like rebuttal time? You have 7 minutes.
Yes, Your Honor. I would if I could have 5 and 2.
5 and 2. For Bedford Webster, this is your cross appeal. Do you wish rebuttal time?
No rebuttal time, Your Honor. 7 minutes.
Okay, so 7 minutes. And for Senera, 7 minutes.
Thank you, Your Honor.
Michigan versus Andrea. Is Mr. Thomas here now?
Yes, I am. Good morning, Your Honor.
Okay, 5 and 1. And for the respondent, 4 minutes. Mr. Visa?
Yes, Your Honor. Good morning.
Good morning. Ross versus Morris is submitted. People versus Anonymous. Mr. Rutgenbecker.
Good morning, Your Honor.
The appellant. Okay, 4 and 1. And Mr. Yetter.
Good morning, Your Honor.
4 minutes.
Thank you.
Good morning to you both. Roberts versus Liberty Lines is submitted. Hashmat versus Cure MD is submitted. Vallacos versus Thomas is submitted. First case for argument is Funkelstein, Bella Funkelstein versus the City of New York. You may begin.
Thank you. If it please the court, as I pointed out, the decisions differentiate between functions that serve the public and functions that serve the governmental entity's proprietary interests.
Mr. Levine, let me ask you, Mr. Levine, I have a question.
Yeah.
So you're agreeing that there's no prior written notice, and therefore you have to show that the city caused and create through some immediate negligence an issue, or that they had some special use unrelated to the use provided by this metal plate. Where do you do that? How have you done that? How have you shown that the city has done that?
Your Honor, I have done that by showing that, consistent with certain of the cases, the function of the vault underneath the plate on which my client tripped and was injured was to provide for traffic signals, and that
So how
other
is that
cases
used
have.
in some way unrelated to the public? How is that a special use by the city, different, unrelated to what it was used for the public, for that light to work and everything else?
The same way, Your Honor, as in the Posner case and in the Storper case, that the court pointed out that the underground vault providing power and utilities to the transit system was not for the public interest, but was a proprietary use.
This was solely to control the traffic signals. Controlling the traffic signals on the street is for the public safety and good primarily.
Your Honor, as two of the cases that I cited, Cam and Murphy both pointed out, the structures that support these that support the traffic function, that the actual lights themselves is part of the traffic control system, part of the public use, but the decisions are not consistent. The decisions are contrary. Frankly, it makes no sense, I think, that power provided to the subway system, which is owned by the city and serves 5 million people a day, is considered a special use. Therefore, this structure, which submits power and to the traffic signals, also is a special use. The consistency is important in the law, Your Honor, and it is the present state of the law, I think, shows that there is no consistency, and that therefore persons cannot be aware of what the law is and cannot govern themselves according to what the law is, because the others go the other way, don't align with each other. We actually see, as far as sewerage is concerned, we see the Ocasio decision that says a municipal sewer system was a special use. Yet then we look at another case, two of the cases, Chambers and Garcia, without offering any reasoning as to why they arrive at their conclusion, say, well, the sewerage system was a public benefit, was not a differentiate, and says, well, yet, as we all know, the subway system serves 5 million people every day, moves.
But even if
those
those cases are
the present state of the law is not
I think we have a couple of questions. And
Final question, even if those cases are outliers, why wouldn't it be the case that the traffic signals would definitely be a public use that can't be described as anything else?
It's not the signals we're talking about, Your Honor. It's what's called the pull box.
Unfortunately, counsel, you're breaking up a bit. We're doing our best.
Differentiate that.
You're breaking up. Just finish your point. Go ahead, finish your point, and then we'll move on to opposing counsel.
Sure.
We have
your. Now I'm having a problem.
Okay, let's get to Mr.
Right.
Your time is up, so let's get to Mr. Osowski. Okay, I'll give you some rebuttal time. You have rebuttal time. Mr. Osowski?
Thank you, Your Honor. May it please the court, Kevin Osowski on behalf of the respondent, the City of New York. The Supreme Court properly granted summary judgment to the city here, both because there was no prior notice and
Mr. Levine's point that it's inconsistent. It's the same power source, he's saying.
Yeah, there's not an inconsistency in the court's jurisprudence here. And when what Mr. Levine appears to be suggesting is a conflation between the court's consistent application of the MTA's use of certain sidewalk appurtenances, which is a special use, and the city's use of appurtenances that either pertain to sewage or provision of traffic regulation. And the Supreme Court here applied to sort of a straightforward application of the law. The Court of Appeals in Poirier versus Schenectady found that traffic signs and the post and anchor that supported that sign, just like the traffic pull box here that supported the traffic signals, promote the orderly flow of vehicular and pedestrian traffic, and are not a special use by the city.
Any questions by the bench? Thank you. Mr. Levine?
Yes, Mr. Osowski has correctly stated the present state of the law, that the MTA, owned by the city, moving 5 million people a day, is somehow a special use, and yet the wires that support the traffic signals, where we also have about 5 million trips a day in the city of New York, is a public benefit. There's no consistency to this. If one is a special use, then the use of the pull boxes covered by the grate with the broken sidewalk over which my client tripped was also a special use. The present state of the law provides no consistency, and I think these cases cannot be reconciled. I believe that this court should find that if providing power to the subway system is a special use, then providing power to traffic signals is also a special use.
Thank you.
Thank you.
Thank you both. People versus Reginald Jones.
Good morning, Your Honor.
Good morning. Just one moment. Mr. Palmer, is that right?
Yes, good morning.
Yes.
My name is John Palmer, appearing on behalf of Reginald Jones. Let me begin. Mr. Jones was convicted of criminal possession of a weapon, sentenced to 2.5 to 5 years in prison for possessing a broken pocket knife.
So let me just ask you, if you would, the fact that this knife could lock, did that make it inoperable? Your client, I think, your client told the officer how to unlock it. So yes. Your client had the ability to unlock it and use it. Why was that inoperable?
It's not that the knife did not unlock, Your Honor. It's just that when the knife was opened, it did not lock into place automatically.
Well, it locked into place when one manipulated it, put one's finger behind it, it still opened up and it could be used as and did operate in the way a switchblade is intended to operate.
Yes, but it must have been manipulated to get there. Mr. Jones.
As I understood the description of it in the transcript, it appeared that all that one had to do to make it lock was to hold your hand up as you were opening it, and then it locked into place. So it's hardly a complicated or a several-step manipulation. It's just a question of how you opened it that caused it then to lock automatically. So why wasn't that operable?
It wasn't operable because it does not matter that the manual step involved in opening the knife or getting it to its open position was simple or easy. There's no dispute here that the person using this knife had to manually fix the blade into its open position. And the penal law defines per se knives by their specific operating mechanisms, and these statutes should be.
And this was one that could be opened by a flick, I think. Is that right?
It could not be opened by a flick.
Well, once it was unlocked, it could be opened by flick. At that point, flicking it.
The officer testified that after he flipped a safety or a switch on the knife to unlock it, he testified that when he pressed the button on the knife's handle, the blade swung up and went beyond 180
not
degrees.
A flick as you would with the other knife, but
with like a gravity knife.
Press the unlock it, and then you press the button, and it opens up, flicks out, opens up. So why isn't that sufficient? I understand what you're saying. He had to keep his hand behind it to make sure it didn't go past the point. But once you do that, it's open. You press that button. The knife didn't stay closed. It opened.
Well, it did not go from an open to its closed position. It's from its closed to open position automatically. And that interpretation, that requirement that it must do that automatically, is consistent with common sense, legislative history, and policy. The statute is ambiguous with respect to open in the switchblade statute, but there is, however, a common understanding as how a switchblade operates. It snaps open to a fixed position on its own. That's how it's understood today.
Except, counsel, this knife did that as long as you held your hand upright so that it didn't go beyond the open position. So it, in fact, as long as you hit the button and held your hand in a certain way, it flicked open and locked right there. So why doesn't that meet the statutory definition?
Because it does not go from the closed to open position automatically.
Counsel, sorry. Go ahead. I was just going to ask counsel to move on to the excessive sentence, unless you wanted to touch on one of the other issues as well.
I could touch, would I be able to switch to touch excessive sentence on rebuttal? I want to briefly touch on Mr. Jones's waiver of counsel. And Mr. Jones did not knowingly, voluntarily, and intelligently waive his right to counsel.
Well, the court didn't, really go into depth about this particular charge and the elements of this charge and the difference. But I don't think that stands in the way of this being a knowing and intelligent and voluntary waiver. The court, more than I've seen most often, went into a very detailed explanation, asking about Mr. Jones's knowledge, in addition to explaining the challenges and risks that go along with not using an attorney. I don't really see what was lacking.
Well, the waiver of counsel is invalid if it does not include the nature of the charges. And omissions
he did
related
talk
to
about what the charge was. He just didn't go into detail on every element of it. I don't think that's required.
The court only asked Mr. Jones if he understood the charge against him in this case. And then just after that asked, do you understand the serious nature of the allegations and potential of a prison sentence if convicted of these crimes?
Do you have any citations to cases where a judge gave as thorough a description as this one, but did not exactly state the elements of the crime? and it was found to be an invalid waiver of the right of counsel?
Not insufficient as to the elements of the crimes. But for example, in Rodriguez, this court found that the court failed to ensure the defendant knew of the sentencing exposure, where that was not included. But otherwise, the colloquy was sufficient in that it pretty closely tracked the model colloquies, which do.
That was not at issue. That's not the same as in this case.
I'd say it's extremely similar in that omissions related to the charge and sentence, as recognized in Cole as required, would invalidate an otherwise sufficient waiver. Yes, the court does have to go and did here into the setbacks, pitfalls, risks of subrepresentation, but the court must also include the nature of the charges and the sentencing exposure. And for that reason, I would ask the court to reverse Mr. Jones's conviction.
Thank you, Mr. Palmer. Mr. Hughes?
Good morning, Your Honors. John Hughes for the people. I'd like to start just very briefly to touch on defendant's weight of the evidence and legal sufficiency claims. Nothing in the penal law definition of a switchblade requires that the switchblade's blade lock into place really anywhere at any specific position.
Let me just ask you, if he does push this, he unlocks it, now he pushes the button. If this were used, would it stay in place if you didn't hold the back of it, or would it close on you?
So as the officer is describing it, when you first press the button, it did kind of sort of overextended, you might say, sort of swung further.
Right, and was it then movable in that position? If he didn't put his finger there? In other words, if you tried to use it, would it then close on you when it was open in that open position?
Well, so what did from there?
Overextended position?
Sure. So after it overextended, the first time he just tried pushing the blade back towards the closed position, and then it clicked into place at the normal 180-degree angle. Also, the officer explained that if you just held the knife in a certain way when you press the button. Yes.
Counsel, are you saying that once it clicked in place, it would not disengage and become unlocked again?
That's correct, Your Honor. Yes, it would click into place once it was in that position.
The knife could be utilized for its purpose.
That's correct, Your Honor. And in fact,
consistent with the statutory definition that we are looking at.
That's correct, Your Honor.
Yeah, what I'm asking is a different question. What I'm asking is, once you click that button and it overextends, if you don't have your hand back to be able to click it into place, is it movable now? If you use it, will it close completely, or in passing that spot, will it lock? That's really my question. If you didn't get to do it yourself and lock it, and you were going to use it, will it just fold closed?
So sort of. I'm sorry, my Amazon Echo is suddenly coming alive behind me. My apologies.
It must be something we said to her.
Right. If the blade did overextend, if you didn't have your sort of finger out to sort of catch it, after it overextended, if you began to sort of swing it back the way it came, then it would click and lock into place at that.
Or I'm thinking, use it against someone. Would it close rather than locking into place? That's really what I was thinking.
So once it's locked into place, there's no indication that it would unlock unless you again press the button. So it does sort of lock into place at that 100-degree angle, and then could be used for its intended purpose.
You have to put it there. In other words, if it's unextended and you tried to use it, would it then close, or would it get into that position where it locked? Anyway, maybe that's beyond the record.
Oh, sure. But essentially, either by holding it in a certain position. When
I understand what the testimony was. I'm perfectly clear on that.
Oh, sure, Your Honor.
Yeah.
And then just quickly to move on to defendant's pro se claim. As Your Honor's pointed out, the trial court's colloquy here was really quite thorough. It spans 9 pages of the transcript. Went over all of the risks and dangers that are attendant for self-representation, and also specifically elicited from defendant that he understood the nature of the charges against him. He understood that he faced, a serious prison sentence. And of course, like most pro se defendants, he may have shown some confusion at some points during the trial, may not have really picked the best strategies, but these are really the exact kinds of things that the court had warned him about, and these are the same risks and dangers that he'd accepted. And so given defendant's responses during that colloquy, the trial court really had no choice at that point but to grant his request to proceed pro se. And finally, since I understand my opposing counsel, excuse me, Your Honors. Since I understand the opposing counsel was going to address excessive sentence on rebuttal, I'd like to go ahead and touch on that right now. So the minimum sentence here would have been 2 to 4 years, and defendant received 2.5 to 5. So this was already very, very close to the bottom of the statutory range. I would note too that there was evidence in this case that 2 days before he's arrested, he's actually threatening a woman with this knife. Which of course is part of what led the police to arrest him in the first place. Also, he had a very significant record. He had 6 prior felonies and 35 prior misdemeanors. Many of those crimes were actually quite recent as well. And so under all those circumstances, we think that this sentence, which was, again, very close to the minimum already, was appropriate under the circumstances. And if Your Honors don't have any other questions, then I'd like to rest on my brief and ask that you affirm. Thank you.
Mr. Palmer. Thank you.
I'd just like to briefly respond to the weight sufficiency argument opposing counsel made before switching back to the excessive sentence claim. So that the knife could be used in its open position once it got there is not relevant to the analysis of whether it opened automatically. The per se knives are defined by their operating mechanisms, not merely that they're sharp or dangerous. And any doubt about whether the knife would actually stay in that position once opened, that's something that we could have been able to determine at a later time, or we could have been able to observe if the knife had not been destroyed. And as far as excessive sentence, all we have here is a simple possession case. Mr. Jones was not indicted for that menacing incident that occurred just a couple of days prior, allegedly. And further, this court has reduced third-degree possession of weapon sentences in similar cases. And further, Mr. Jones does have an extensive, lengthy rather, criminal record, but many of those cases appear to be drug-related simple possession cases that could evidence that he may have or have had an addiction problem that led to those offenses. And finally, he did try to go through some rehabilitation efforts while he was incarcerated before trial. As stated in the brief, Mr. Jones participated in a barbering program at Rikers Island where he mentored younger inmates. So for those reasons, I would ask the court to reduce Mr. Jones's sentence to 2 to 4 years in the interest of justice. Thank you.
Thank you, gentlemen. Thank you both.
Thank you.
Next case is China Privatization versus Galaxy Entertainment. Just a moment, please, Mr. Bookdahl.
Yeah, I think of it as book doll, like a book and a doll.
Yeah, no, I did say that, Bookdahl, I believe. Okay. You may begin.
May it please the court. The conversion formula at issue here explicitly states that the...
So I have to stop you right there and say that, you have the pleasure of having every one of us on this panel having been on some iteration of this case. And so I'm going to just get right to it and say ambiguity was the question, right? That was what we found.
Correct.
And that was what was addressed, the determination, trying to figure that out through extrinsic evidence, parole evidence, was what the court was trying to do. And so one of the testimony, I understand why you would want to find Mr. Barron's testimony incredible, but he was the lead counsel for the consortium, and he didn't forget his original testimony. In fact, I think this court, and my colleague was on that case, found that he was asserting attorney-client privilege, and it was said, no, you have to answer the question. It went back. I think Judge Oing was below and said, yep, You have to answer the question. And in fact, he testified in this case, remembering everything. And in fact, that he never instructed his clients, never was instructed by his clients to draft a document that reflected a moving floor. So why isn't his testimony competent evidence of contractual intent?
That's exactly the right question, Your Honor. And the reason it isn't is because Mr. Barron's testimony was nothing more than a legal argument about how to read the contract. Because if you look at Mr. Barron's testimony, it's in its entirety. First, he said that he didn't remember the indenture. Then he said that he didn't remember how Section 13.08 worked. And you're right that he said he didn't have instructions to implement a moving floor. But that's not really what's at issue here. The issue is, how does this court interpret 13.08? And even though Mr. Barron helped draft the contract, he had no explanation whatsoever for why Section 13.08 says that the initial reference price shall be revised. Instead, Mr. Barron's testimony just repeated what amounts to a legal argument. All he said, and I'm not exaggerating, you can look at page 10,098 of the record, page 281 of his deposition. All he said was that the separate definition of initial reference price controls and renders superfluous the literal operation of Section 13.08. And that testimony from Mr. Barron should sound familiar to all of you, because that's the exact same argument that this court rejected back in 2012 when it affirmed Justice Owing's decision denying Galaxy's motion to dismiss. Because all
didn't I just have to add this, doesn't he talk about the initial reference price and that it can change only in the event of dilution pursuant to 1309 and 901, and then he says, and Section 1308 does not change the initial reference price?
Right, he says that, but he does,
but you're saying he doesn't mean that.
No, he meant it. What I mean is he is just making the same legal argument that Galaxy made, because what he cannot do is say, why do the words shall be revised? Why don't those apply? He doesn't have an argument for it. He doesn't have an explanation for it. I understand that when this court said, go look for extrinsic evidence, we were all hoping, right, at that time, that when people went back and deposed the relevant witnesses and uncovered the relevant documents, that someone would find a piece of evidence that said, here's how that works. Here's how it works, that when this Section 13.08 says, shall be revised, here's what you're supposed to do. Nobody had that. And Mr. Barron was no different from anyone else. Remember, he was deposed 10 years, literally 10 years after the drafting of this contract. And he acknowledged quite candidly that his testimony was based on term sheets that he remembered. He said that he didn't remember any conversations with the other side, no conversations with Galaxy. He didn't remember any conversations with his own client. He did talk about his own intent, but remember that he's not a party to this case. His intent actually doesn't matter that much. And there's never been a case that
Counsel, at that time he was counsel for the client.
That
and
is correct.
His understanding of what the intent was is not a question. See, I have trouble understanding his testimony as being a legal opinion. Rather, it was his description of what he remembered the facts to be at the time of the drafting.
So
that's a very different thing from an opinion. He was describing with the intent that they were trying to accomplish by writing it in the way that they wrote it. That's right. That's testimony as to facts, not opinion. So I'm having trouble understanding why you are considering his testimony to be opinion testimony.
I don't consider his testimony about those facts to be opinion. That is certainly, he can testify about the facts as he remembered them. What I'm saying is that his testimony about the contract itself and the words of the contract itself was opinion testimony, because he did not actually provide any explanation for why the words shall be revised instead mean shall not be revised. Because make no mistake, that is what Galaxy is arguing here. They're saying that the words shall be revised in the contract actually don't have any effect. And that's exactly what a court is not supposed to do, is interpret a contract in a way that takes words like shall be revised.
Counsel, this is Judge Owen. I'm not so sure, Supreme Court, this was a bench trial, and Judge Maisley heard all the testimony as well as documentary evidence. I'm not so sure we can just focus on this particular individual's trial testimony as being the basis for her finding. I mean, she also looked at in terms of the Hong Kong Stock Exchange, how it would affect in terms of the economics if you had a moving floor versus a fixed floor, how it may violate actually the exchange rules. There were a lot of things going on there. So it was like a puzzle that she was putting together. And unfortunately, the puzzle that she put together was not favorable to your client. It was favorable to the defendant in the case. So that's where it goes. We can't just focus on this one individual's testimony as saying clearly you're trying to undermine it and saying, it's not what it's supposed to be. But there were other things. There were thousands and thousands of pages of testimony here. It's not just like it was based on a 5-page, transcript here.
All of that.
And I think just to add on to Judge Oing, and I think 500 exhibits or something, including an email from CPF's manager, Bacall, the day after the deal, I think, closed, that said the lowest price is 6.20 or plus 20%, which was essentially the Hong Kong's $7.44 amount. So that's the day after the deal closed.
If I may now respond to some of these questions.
Go ahead. Sure.
Okay. So first of all, let me start with that last one. At the time that Mr. Bacall wrote that email, that was true. That was the lowest point at that day. That was before what happened in the next 2 years, which was that the bottom fell out from the stock price. No one anticipated this would happen, that in the years 2007 and 2008, the stock market would crash and the stock would take such a beating. But that's what happened. Now, as for the centrality of Mr. Barron's testimony, it's not me who's saying it's important. Justice Maisley referred to that testimony as critical to her decision. It is the most important leg of the stool she tried to build. As far as Justice Oing's question about the many pieces of evidence, you can have a lot of pieces to a puzzle, but if each of those pieces is inadmissible, then it doesn't add up to a picture that this court can rely on, because ultimately what has to happen is that this court has to construe the contract in a way that is faithful to its words, because as Judge Learned Hand warned over a century ago, strictly speaking, the intent of these parties is irrelevant. You have to interpret the words on the contract, and shall be revised has been torn from this contract and thrown in the wastebasket. Now, as far as
I'm going to end with, yes, go ahead. If you wrap it up.
Yeah, as far as the Hong Kong Stock Exchange goes, as far as the Hong Kong Stock Exchange goes, there was no testimony that there was ever any violation of any rule. All that was argued is that hypothetically, if the stock moved in a certain direction, enough shares could be issued that would violate the mandate as it existed. By the way, the mandate could be changed by the shareholders, but there was never any actual violation of any rules. There was just a suggestion that at some point in the future, too many shares could offer. But our client's position, the amount of shares necessary to satisfy our client and to enforce the actual words of this contract, does not violate any rule of the Hong Kong Stock Exchange, and that was never argued that it would.
Thank you. And I think Mr. Vizza is next. No, I'm sorry. Mr. Katz?
Yes.
Katz, yes.
Thank you very much. May it please the court. The trial court watched hours of Mr. Barron's testimony on his resumed deposition, and without all of the obstruction from the privileged objections, the court found, as a matter of fact, that Mr. Barron was in regular contact with the investors, that they communicated the terms directly to him, and there are scores of documents in the record that were discussed at trial that showed that the entire distribution list was privy to Mr. Barron's drafting. Mr. Barron remembered directly that, as Your Honor noted, that he was never directed to incorporate a moving floor, that it was well understood and not controversial. And contrary to what Mr. Buchdahl has said, as a matter of fact, the trial court did analyze in detail, guided by Mr. Barron's testimony, the shall be revised language. And my colleague likes to quote that in isolation, but the entire phrase says, shall be revised, and as so revised shall constitute the revised reference price. And it's the revised reference price that Mr. Barron said moves up and down between the fixed cap and floor. And he said, if you look at the definition of initial reference price, it says that the initial reference price is not affected by the reset mechanism. So the intent of this document was for the revised reference price to move. Under my opponent's interpretation, the initial reference price and revised reference price are always exactly the same. Another thing that Justice Maisley did is she looked at the upward reset that's built into 1308B in the reset mechanism is a barometer of the party's intent. And every single party, including Mr. Bookdog Client, said that the parties intended an upward reset. And the court found that under CPF's interpretation, the upward reset is inoperable. And under Galaxy's interpretation, it does operate. And it did come into play, contrary to what my opponent said in the brief. In the fourth period, the price of Galaxy stock went up. But because the initial reference price equals the cap price, the initial reference price under their interpretation did not reset up. So Justice Maisley analyzed it, and Mr. Barron, who was the principal drafter, he remembered everything. He talked about his interaction with Canyon. He said, I remember this email from Henry Cheung. He also said, I remember how the words then applicable were selected. This court found that was ambiguous. He said then applicable was used to denote dilution adjustments, to make sure that the cap, the floor, the initial reference price, if there was dilution, they would be adjusted. That's why it was there. He also said initially in the definition of initial reference price was also there to denote that the initial reference price could change, but only subject to dilution. He said, quote, clients are absolutely paranoid, unquote, about dilution adjustments. And so Justice Maisley found, based on Mr. Barron's credible testimony, she made the credibility determinations watching hours of his testimony, that this was done as a measure of technical clarity. Now, regarding the question about the Hong Kong Stock Exchange, this court has held in the Waverly case that the best evidence of intent is the conduct after the contract is formed, after the contract is fully baked. And so what the court found is that Mr. Bacall, the principal, he actively noted and implied a 744 price for years until CalPERS threatened his own financial interests. The reason why there was no discussion about a moving floor is because Justice Maisley found that that was never in anybody's contemplation, that new interpretation was fabricated 4 years after the fact by strangers to the negotiations, and then under financial threat, Mr. Bacall adopted it. Their other star witness was Mr. Swati, and Mr. Swati, the judge made credibility determination and said that his testimony was not credible. There was no written documentation that corroborated that the parties ever intended a moving floor. Mr. Swati didn't update the investment memo to indicate a moving floor. Mr. Swati absolutely gave, no credible testimony whatsoever to indicate that the parties at the time intended to have a moving floor. And regarding Your Honor's question about the email that was sent one day after, that wasn't just based on the next day. Mr. Bacall told an investor who had the interesting handle Lobster Lover that the lowest conversion price is $620 plus the conversion premium. Then in investment memoranda to his clients, within 2 weeks after the deal had been reached, he wrote that the lowest conversion price is $744 and indicated that that would be in place throughout the entire indenture. He also said that the price could move up and down. He then applied the fixed floor and $744 conversion price in 4 years of CPF financial statements. Those are all party admissions under the Nappy case, wherever, whenever, and to whomsoever made. The trial court also made credibility determination as to Doug Ostrover, said he was the most credible and reliable witness. He was laser focused on the reset mechanism. He never even heard of a floor price that could move. He was in the call with Mr. Louis when supposedly this last minute change occurred and said it never happened. Then you had to mark the notes to market because Mr. Ostrover had investors coming in out of the fund. And he marked the notes to market at the $744 lowest conversion price. There was a due diligence memo in 2009 after the stock had plunged, indicating that the lowest conversion price was $744. That was the deal they struck. Canyon was an original investor. Canyon, one of the most sophisticated hedge funds, said that they were actively involved in the negotiations. Bill Barron talked about his interactions with Henry Cheung of Canyon, and Canyon said when they converted the notes at the same time as CPF, that $744 was the lowest conversion price. Plainfield, the judge made a credibility determination about Mr. Burley and said that when Mr. Burley was asked at his deposition, what about a moving floor? She said Mr. Burley's confused look spoke volumes. He was involved in setting the commercial terms, and he wrote an investment memo in 2007 saying that there was a fixed floor. All of this, none of this was uncommunicated subjective intent. It was widely communicated. All the investors were involved in the Hong Kong Stock Exchange process. That Hong Kong Stock Exchange notice, which went out to the investing public, said that the lowest conversion price is $7.44. And that had to be said because the investing public needed to know what is the maximum potential for dilution. And that was 215 million shares. There was uncontested testimony that the court noted from David Norman, who represented Galaxy, saying that these XX shares that CPF is claiming would have been unlisted and illiquid. The deal would have been illegal under CPF's interpretation and subjected the participants to criminal liability. So the court applied well-established law that you don't interpret an agreement to yield an illegality. And it was the Hong Kong Stock Exchange announcement was no secret. It wasn't uncommunicated. And Maria Kang sent an email to everybody saying that Galaxy used the lowest conversion price to calculate the maximum number of shares. And that was
Thank you,
$7.44.
counsel. If you would wrap up your thought, your time has just ended.
Thank you. May it please the court, I will just conclude by saying Justice Masley did exactly as this court directed. This agreement was deemed ambiguous. That's law of the case. And she held a trial to determine what the party's intent was. And there was just an avalanche, overwhelming, as she said, evidence indicating that the parties intended a fixed floor, and we ask that this court affirm.
Thank you.
Thank you.
Back to you, Mr. Bickdahl.
Thank you. I was holding out hope that Mr. Katz, after all these years, would finally explain why shall be revised means something other than that. But he couldn't, because no one can, because it's impossible to reconcile Galaxy's interpretation of this document with the actual words of the indenture itself. And I urge you all to go back and look at page 10,098 of the record, page 281 of Mr. Barron's.
I got a question. You know, if it were that simple, the shall be that you keep saying, why'd you even have a trial?
I don't.
That straightforward and straight up.
I don't know that a trial, strictly speaking, was necessary. We moved in limine before the trial.
You moved for summary judgment. Did you move for summary judgment on this?
We didn't move for summary judgment because there was some evidence that could have been considered. But when we moved even to exclude this evidence, the judge refused to, and she relied in significant part. She called it critical to her decision on testimony that should not have been allowed. Justice Oing, Mr. Barron was asked under oath, do you recognize this as the final indenture? His answer, I do not remember this document. He was asked under oath. Do you have any understanding?
Focusing a lot on Barron when there was like a lot of other people testifying.
All of the other participants did not participate in the negotiation of the document. Mr. Katz,
I understand that, but this is also after the fact because we're talking about extrinsic evidence, the course of conduct after the contract was entered into.
But there wasn't actually a course of conduct, Your Honor, because they didn't actually convert their shares. They sold back these bonds to Galaxy. So with one exception, Mr. Ostrover didn't convert his shares. You know, Plainfield didn't convert their shares, so they never actually had to apply a conversion price. So for them to say, well, I understood it was X, Y, or Z, they never had to put their money where their mouth was. And it is absolutely critical that this court go back and look at the words of this document. It just can't be read the way they want to read it. It can't be done because the words shall be revised need to be given meaning. It is not the case, as Mr. Katz falsely claimed, that in our view, the initial reference price and the revised reference price are the same, because it's the initial reference price at the beginning of the period, and it may change to the revised reference price toward the end of the period. But if you look at the words of this indenture, it says it could not be more clear that the initial reference price shall be revised and be a different number in the next period. And I was waiting for Mr. Katz to explain that. I was waiting for Mr. Barron or someone to explain that. But look at page 281 of his deposition. He's asked, was it your understanding that it revises the initial reference price? And all he says was, no, of course not. How could that be? But he doesn't actually grapple with the language. And it's this court's duty to grapple with that language, because it's not okay to just say to any future investor, to just say to them, hey, we went back and we talked to a lot of earlier participants and they all agreed what the deal was. It's got to be consistent with the language. Anything other than that threatens the very foundation of marketable instruments. Anyway, if there are no other questions, we'll rest on our papers.
Mr. Bookdahl, thank you. Mr. Katz, thank you. People versus Edwin Baez.
Good morning, Your Honor. May it please the court, Claudia Troop on behalf of Edwin Baez. In this case, the jury had a very narrow issue to decide. The only contested issue at trial was whether Mr. Baez possessed an intent to commit a crime within the building at the time of the assault on the complainant, or whether it was a spontaneous action that arose after the complainant blocked his ability to see his girlfriend. It's in the context of that narrow issue.
A right that your client did not have based on the order of protection.
The order goes to the contempt charge, Your Honor, but not to the burglary charge. The jury was specifically charged that the violation.
He made that argument as though he possessed the right to be there, which he did not. He was specifically ordered multiple times not to have any contact with this woman.
Yes, and that's true. And that establishes the trespass element of the burglary, but not the intent to commit the crime therein, which are the two separate. And the jury was specifically charged that they had to find that the defendant possessed a separate intent to commit the crime therein. And it's in that context that the introduction of all of this uncharged evidence, which was voluminous and prejudicial and remote, prejudiced Mr. Baez. The court allowed in numerous text messages, numerous voicemails from 13 months before this incident. That was in addition.
Counsel, why wasn't that an appropriate means of proving his intent in terms of his ongoing relationship with his ex-girlfriend, to whom he had been violent and threatening over a long period of time? I have difficulty understanding your argument as to why those messages back and forth weren't probative of his intent.
Because they were simply too, I'm sorry, Your Honor.
Could you explain that to me?
Yes, they were simply too remote. They were 13 months earlier. And in addition, even if they were somewhat probative, the probative value was outweighed by the prejudicial effect. There were numerous.
Know about domestic violence. This is not a one-time incident. It's a course of.
Of course, and we're not saying.
Fine, go ahead, interrupt.
I'm sorry, go ahead.
It's all right, go ahead, answer what you thought you were answering.
It is, of course, the rule that some background information comes in the context of domestic violence, and that certainly came in this case. Both the complainant and Mr. Baez's girlfriend were able to testify about the nature of the relationship. There was testimony that he had previously, on another occasion, pulled a knife on the son. There was testimony about the threats and all that had gone on. There was no inability of the jury to understand the nature of this relationship. What didn't need to come in was 13-month-old text messages and voicemails, which caused the complainant to break down, hysterically crying.
Counsel, this is Judge Owen. Was there an objection to the court's instruction about those text messages?
No, there was not an objection to the specific instruction. There were repeated objections to the volume and the detail. I understand that,
but when the court gave the instruction to the jury with respect to the text messages, was there an objection lodged?
No, and we are not complaining on appeal that there was any error in the instruction. What we're complaining is that
would mean that the jury continually is always assumed to follow the court's instruction in terms of limiting what those texts were supposed to do, correct?
There was a limiting instruction, but this court and others have
The court
recognized.
said, the court specifically said, understanding that it, meaning the text message, is not offered to show some propensity on the part of the defendant.
Yes, there was that limiting instruction. The court also recognized and expressed concerns that the volume and detail of this evidence would overwhelm the issues in this case, and that is what happened here. I'd like to take a moment to talk about sentences if I could. At the time of this incident, Mr. Baez was 62 years old, and he had been diagnosed with Alzheimer's disease. He was receiving therapy for that. He has additional physical problems in the terms of he has cirrhosis. He has been diagnosed with schizophrenia. His health has deteriorated to such a point right now that he can no longer be housed in general population. He has to be at Walsh Medical Facility receiving particular attention. He has supportive family in his niece and his sister who have offered to take him into their homes.
I have a question. Certainly he was already of that age at the time he committed these crimes, and didn't he already have several of the conditions you've already described? It doesn't appear that those interfered with his ability to act in this way towards his ex-girlfriend and her son. So
he had recently been diagnosed with Alzheimer's and dementia. As your honors are, I'm sure, aware, that is a degenerative disease that progresses at various stages. He's now over 65 years old and has progressed to a degree that he can no longer be in general population. We're not saying that he doesn't deserve to be in prison at all. The minimum sentence here is 8 years. What we're saying is that the minimum is more than adequate to punish him for what he did here. His prior conviction was his most recent prior conviction was for drug. It was a drug sale. So this is not somebody who deserves to be in prison beyond 8 years, which is the minimum, which is a serious and significant deprivation of liberty. And to keep somebody who is suffering from dementia and Alzheimer's imprisoned beyond that time period is simply inhumane. And we would ask your honors to reduce the sentence to 8 years, which, as I said, was the minimum in light of these serious health problems that Mr. Baez suffered.
That would be a reduction of 1 year?
Yes,
it would be a reduction of 1 year?
Yes, it would be a reduction of 1 year. Thank you.
Ms. Pollock?
Hi, Ellen Friedman, Your Honor, representing the people.
Oh, I'm sorry.
That's okay. That's okay.
Yes.
Your Honors, the text and voicemail messages that were emitted were both relevant and limited in order to prevent any
counsel, this was an awful crime where, this defendant clearly wasn't the first time he had violated an order of protection, attacked the girlfriend, but how much of this kind of background evidence is necessary to give this kind of background, and how much makes a charge, even though the charge wasn't objected to, there certainly was ample objection to the amount of this evidence coming in. How much of this evidence just is just so much that it makes the charge, I don't want to say irrelevant, but the jury's not really hearing that charge?
Yeah, I understand your question, Your Honor. And the fact is, in this case, the judge actually limited the amount of evidence that came in. I believe that people asked for permission to admit evidence from 2013 through 2015 messages from that time period. And the judge did recognize the relevance, but also sought to minimize any potential prejudice and denied that motion in part, and granted it only from April 2015 and after, not from before that time. It additionally required the people to present it in a streamlined and concise a way as possible, and made it clear that it would be issuing the kind of limiting instruction to the jury. So I think, wherever the line is, that would be too much. It certainly didn't get crossed in this case. The judge was very careful. And the messages were certainly relevant to both the background of the history between Olivencia and the defendant, as well as to the defendant's intent. Because not only did they go to the issue of that relationship starting in April 2015, but they showed that he had threatened to hurt her sons in the past in order to prevent her from seeking legal protection. So that was directly relevant to the intent element. And beyond that here, the probative value did outweigh any potential prejudice. Not only did the court limit the messages that were allowed in the way that I just mentioned, but that also issued the limiting instructions reiterating that the messages were only relevant to the mental state and to the background of the relationship. And another point is that the jury did already have an understanding of the defendant's criminal past. The people weren't limited to presenting the minimum amount of evidence, but there's certainly not much prejudice that could have been inferred from these text messages alone and a few voicemail messages also.
Counsel, this is Justice Gesmer. I have a different question. Given the defendant's age and his degenerating health condition, why wouldn't the purposes of the criminal justice system be served by reducing his sentence to 8 years instead of 9? Why would that be inadequate to give him appropriate punishment and protect the public?
Your Honor, this was his third conviction for criminal contempt. He entered the building in violation of an order of protection. He violently slashed Olavencia's son.
I understand all of that, but
yeah, and the fact of the matter is his age and his medical conditions haven't served to reduce his willingness to harm those victims. And in fact, his conduct, the violent nature of his conduct escalated over the years.
You agree, counsel, come on, you agree that someone with Alzheimer's and dementia over time will not even be able to recognize himself and his family. So yeah, why would justice not be served by reducing it by 1 year? I mean, they're not asking to release him to his family. It's 1 year. And I do not at all, like my colleagues, diminish the outrageousness of his conduct.
Right.
But why is 8 years not enough to address it?
And counsel, and to that point, to Justice Manzanet's point, how much more time does he have to serve? I'm just curious.
I don't have the answer to that question at my fingertips. Okay. If you'd like, I can look it up. No. The fact of the matter is his physical and the fact of the matter is Alzheimer's, I believe, affects different people in different ways. So I'm not sure that you can say that because he has Alzheimer's, which generally speaking is a degenerative disease. We know how
that he's separated from the general population because of the disease. So you're right, it affects different people different ways, but given taking that, if he's separated from the general population, that reflects the way it's treating, he's being affected by the disease, right? That's right. What we're...
Okay, that's the, yeah, our position is that the 9 years, which is very close to the minimum, is the proper sentence in light of the escalating nature of his violent behavior and the fact that he did have these conditions when the crime occurred.
Okay, but you didn't answer the underlying question, which we've all posed to you, is why wouldn't the purposes of the criminal justice system be served by reducing it to 8 years, given the degenerative nature of his disease and the fact that it's already serious enough that he's removed out of the general population?
Because given the conduct, given all of the facts looked at holistically, we believe that the 9 year sentence, which is very close to the minimum, is the appropriate one.
Thank you. Ms. Troop?
Yes, just to answer Justice Ng's question, he would need to serve till 2025 would be his maximum expiration. With good time, it would be a conditional release date in 2023 with the current sentence.
And how old will he be then? How old will he be then?
He'll be 69 at that point.
At 2023?
In 2023. He'll be almost 70 at that point.
At 2023, which is the earliest he can be released.
Yeah, and he'll be almost 70 at that point.
Okay.
When he and I just also want to.
So the release is not imminent. Essentially, the release.
It is not imminent, and I do want to emphasize that he is a person who has family who is willing to take him into their homes. This is a situation where somebody should be with family and not the responsibility of the criminal justice system.
So he's currently not in the general population, though?
He's at Walsh Medical Facility. He was transferred in November 2019 from Auburn, where he was in general population.
Right. Okay.
Thank you.
Thank you.
Thank you, Ms. Troop, Ms. Friedman. Thank you both. People versus Paul Manafort.
May it please the court.
Just
Valerie-
one moment, please. Okay. You may begin.
May it please the court, Valerie Figueredo for the people. This court should reverse Justice Wiley's order and reinstate the indictment because the people's prosecution of defendant is permitted under CPL 40.202B. In concluding that the
Counsel, if I might just, double jeopardy obviously is broad in New York State. It's applied broadly. I understand that there are exceptions, but I'm wondering how the exceptions here for the charges that have been brought are address a different harm or evil. Just to pick one of them, for example, the mortgage fraud, the residential mortgage fraud that's being charged. I mean, I think your argument is that it's only to protect homeowners, not to protect financial institutions and mortgage lenders. For example, how is that a valid argument?
It's going to the residential mortgage fraud statute. That statute was enacted to prevent a very different harm. Yes, it was enacted to protect homeowners from losing their homes. That is a specific class of victims that's distinct from the bank fraud statute, which was enacted to protect financial institutions from economic harm. We know from matter of Kaplan that what you do for purposes of addressing the harm is looking at the specific harm the legislature was trying to prevent. If you look at the text of residential mortgage fraud, we know from the text that they were trying to protect homeowners because they exclude homeowners from liability in certain circumstances. We also know from the legislative history that they were trying to protect homeowners because homeowners are the only group of individuals who are listed as a group being protected under the statute.
Wasn't this all due to the 2008 crisis? I mean, that's how this came up for the homeowners and for the banks. I don't see how this mechanism wasn't to protect, stability of the overall economy. I mean, that is what the harm and evil was here.
Or phrased differently, financial fraud phrased broadly. And I have difficulty understanding why that's a very different kind of harm or evil, which is the standard.
Two responses, Your Honor. First, to define the harm as broad as saying that the residential mortgage fraud was just targeting protection of the overall economy would essentially nullify the exception because all fraud crimes, broadly speaking, when viewed broadly enough, are designed to protect the overall economy. Matter of Kaplan says that you do not look at the overarching evil. When Matter of Kaplan defined the term broader evil, it said you look at the specific harm the statutory offenses were designed to prevent. That is the very narrow harm you are looking at. Here with residential...
Excuse me, couldn't we also define it a little bit more narrowly as fraud in the mortgage lending industry that triggered the 2008 financial crisis? That's a little narrower, but it seems to me that both of the statutes here address that. So why isn't that broad enough to include both categories, but narrow enough to avoid the kind of problem that you're describing?
There's no denying that the state legislature was responding to the financial crisis. However, it did so for an entirely different objective and to protect an entire
Mr. Blanche?
Yes. Good morning, Your Honors. May it please the court. I'd like to start with where the district attorney just dropped off, which is really the question is not whether one part of the bank fraud statute is to protect the financial institutions. Of course it is, but also whether that statute is broad enough to protect homeowners, which of course it is, whether it's broad enough to protect consumers, which of course it is. And then when you flip that and talk about the residential mortgage fraud New York statute, that is also a broad enough statute to protect homeowners and to protect financial institutions. Indeed, there's plenty of cases where the people have brought residential mortgage cases, and they're in our brief, against where the financial institution is the victim. But more significantly, the real problem with the people's argument as it relates to this is the following. Everybody agrees that the only victims in this case, whether it's the federal case or the state case, are the financial institutions. So how can it be that the people want an exception? They seek an exception under the very, very different harm or evil exception to the double jeopardy statute, saying that there's a whole different class of victims in the residential mortgage counts of this indictment and the consumer fraud of this indictment, but they do not even allege that they're victims in this case. Everybody agrees the only victims in this case are the financial institutions. Now, to be clear, there are times.
So by their argument, as you point that out, that the victims in this case are the financial institutions, there's no, the state mortgage statutes don't even apply that, right? I mean, by their own argument, saying that only the state mortgage provisions are to protect the consumers, right?
Correct, Your Honor, and also the consumer fraud counts as well. And I don't think they really believe that, by the way, because they got an indictment. There's a true bill returned. They recognize that both of the consumer fraud statutes and also the residential mortgage statutes and all the other counts in the indictment are broad enough to cover the conduct alleged here.
Well, they're making the argument now to get over the double jeopardy problem now. I mean, I see what you're saying. They got enough to get the indictments, but now they're going to do a pivot to try to get over double jeopardy.
And that's where, if you take their argument to its logical conclusion, that would assume that the legislature came up with this very stringent double jeopardy body of law, which has been affirmed repeatedly by this court and by higher courts. And yet there can be a loophole if the state can bring a count like they did here under the consumer fraud or the residential mortgage, where they allege a different class of victims. But to be sure, they're wrong about that. That's not true. The class of victims, the potential harm in the federal bank fraud statutes and the mortgage fraud and all the statutes brought here are one and the same. They're overlapping, and they overlap heavily. So for both the arguments, for both those reasons, the people's argument really has to fail. And Judge Wiley got it right. And that's what Judge Wiley's opinion essentially said. We're not asking the court to create new law. That's what the people are asking the court to do. The people are asking this court for the first time ever, to create this bizarre class of victims exception, which Kaplan does not speak to. Notwithstanding what the people say in their briefs, Kaplan does not speak to that. That is not the holding of Kaplan. And if you look at what this court did, the First Department did in Helmsley shortly after Kaplan, there was no, and Kaplan was heavily cited, this court recognized no such exception with some class of victims argument. So look, at the end of the day, Your Honors, there are hard cases and there are easy cases, but this isn't a hard case. This is not a hard case. This case requires, just like what Judge Wiley did, it simply requires this court to follow the law, follow the precedents, and look at the facts.
Thank you. We're back to you, Ms. Figueroa.
Sure. Addressing the defendant's argument, there is no tension here in the people bringing this case for fraud based on harm to the banks. Matter of Kaplan explains that where you do not look at the particular facts of the prosecution. You're looking at the specific harm the legislature was intending to prevent. Here, for instance, if you look at Matter of Sharpton, that was a case that involved a prosecution for scheme to defraud. The alleged harm, as alleged in the facts of that case, was to the state. Nonetheless, the harm to the state was being prosecuted under the scheme to defraud statute, which we all understand, based on its legislative history, was intended to protect consumers. The fact that the statute can reach conduct does not mean that it was the principal or motivating conduct that the legislature was trying to prevent, and that's illustrated in matter of Sharpton. Defendants.
What about the Helmsley case that counsel cites with the state and federal tax fraud?
Right. So Helmsley involved initial prosecution under the federal law for failure to file a false tax return and mail fraud, a subsequent state prosecution for also failing to file the false tax return and falsifying business records. This court evidently concluded that cheating the federal government and cheating the state government out of money did not satisfy the exception, presumably because it wasn't different classes of victims, and at bottom the tax laws all seek to remedy the same financial loss. However, Helmsley has little value because after Helmsley, the legislature effectively overruled that decision when it enacted subsection 2I. In that provision, the legislature now allows the exact prosecution that this court concluded was not permitted in Helmsley. So
you're saying this is a legislative issue, not one for us?
It's clear that the legislature has already made the determination that despite New York's broad double jeopardy prohibition, it is too broad, and in certain circumstances, it has wanted to vindicate, as a matter of New York policy, New York's interest by permitting the state offenses to be prosecuted. This is one such instance where, when you look at the specific harm these offenses were designed to prevent, they are all very different than bank fraud. There's no dispute that the offenses are broad enough to cover the same conduct. But as People v. Bryan and Matter of Sharpton, as well as other cases we cite in our brief illustrate, the fact that there is some overlap does not foreclose application of the exception.
Thank you. Any other questions from the bench? You stopped just as your time was up, so you must be watching the clock as well. Anyway, thank you both.
Thank you.
Thank you, Your Honors.
Next case is Senera versus Bedford Webster. Just a moment, please. Ms. Finocchio? Yes.
Marie Hodukovich for the
defendant
appellant, 3170 Webster.
Yes, you may begin.
Thank you. And for third-party defendant appellant Joy Construction.
You're for 3170 and Joy.
Yes.
Correct? Yes. Go ahead.
And so this case is about there's a construction project going on.
Yes, we're aware of the facts of the case. He's on his tractor moving the pallets, falls through the floor.
Right. But the property that's under construction is 3170 Webster, not 3160 Webster. This is a property that had been licensed by Joy for storage and materials.
Right adjacent. The building right adjacent is where they're storing the cement and such.
Yes. So the question with respect to the Labor Law 240 case is whether or not the plaintiff was exposed to a foreseeable risk of an elevation-related hazard, which would cause the defendant.
So why wasn't this foreseeable here, where the owner of the building gave the license to the other party? I mean, clearly they had to have known. The 3170 sent its people in there, and Joy sent the gentleman in there whose hand went straight below the ground, straight into the hole, 3 separate holes where his hand could fit right through, and couldn't even tell where the bottom was because there was just space. And frankly, where it took 30 bags of cement they used 30 bags of cement is the only way I can put it, for some cracks, for what's described as some cracks. How is this not foreseeable?
Actually, Your Honor, his hand didn't go straight through the floor to open space. He encountered some metal. He encountered a metal or a steel.
What I think his testimony was that he saw some metal, or there was some metal down there, but he couldn't tell how much the distance was because his hand just went in. There was no bottom. He didn't find a bottom.
What you've just described sounds like he put his hand through the cement floor and touched rebar, which would require an inspection. Why was an inspection not required in this situation? How do you get how can you say it's not foreseeable when there was no valid inspection?
Well, in
And
fact,
just to tag on to what my colleague has said, the fact that it was rebar shows it wasn't dirt, shows there was no dirt, shows there was nothing there to support the floor. So please answer my colleague's question.
Yes, okay, with respect to the inspection, in fact, the plaintiff was directed by his supervisor to fill the cement, so they knew about the hole, to put the, fill the hole.
That's not the
They knew
question.
about that.
That is not the question. This worker is not an engineer, correct?
Correct.
Why was not a structural engineer called to this site to inspect the cracks on this floor, knowing the purpose that this site was going to be used for, to hold thousands of pounds of construction material and bring in a forklift, for God's sake, to move the material in and out of the building?
Your Honor, Joy was operating in this building under a license with the owner, which is Bedford Webster. So we have the license to use what they said was a portion of the building.
That wasn't my question.
May I proceed? I'm going to try to answer your question.
Counsel, I've asked a question. Why was there not a structural engineer hired to inspect this premises before, especially in light of the use that it was going to be used for?
Your Honor, I don't see that was their obligation, because they had a license and the owner of the property.
So what you're saying is, once they had the license, they could send their employees into that building blindly, knowing full well that there was a space or some ill-equipped flooring that could potentially lead to their employee falling through. That's not what you want us to, that's not what you're telling us.
Your Honor, once the crack was repaired, there was no recurrence of any crack or any defect. There was
This
no
is a crack I have never, look, I don't want to play expert here, and I hate to bring in any personal experience or anything else, but I cannot fathom how it takes 30 bags of cement to fill what you are calling a crack. Common sense, to me, that defies credulity and understanding.
And counsel, let me just add to that. Even if they didn't have a duty to inspect when they got the license, and even if they didn't have a duty to inspect when the cracks first appeared, once the cracks could only be apparently fixed with 30 bags of cement, why wouldn't that make it foreseeable that there's some huge hole underneath the floor that required an inspection by a qualified person before allowing your employees to proceed to drive back and forth with a forklift and thousands of pounds of equipment? That's the point at which I can't understand why it's not foreseeable that there's a problem. Could you explain that to me?
Your Honor, once they filled the crack, they used it, and there was no evidence of the recurrence.
I just don't understand. But anyway, your time is up. Perhaps you'll think about a different way to phrase it when we come back. This is Bedford Webster.
Good morning, Your Honors. I represent a series of parties on this. The first point that I want to...
We're aware. And I think that the questions we've posed to Ms. Finocchio I think I've used your wrong name, I'm not sure, but will also be posed to you. So why don't you go ahead and answer them? Assume they're the same.
Well, if you'd like me to answer the question that you were harping on.
Why wasn't there an inspection? Why wasn't this foreseeable? Those questions.
Those are valid points, but I just wanted to address that the court is of the mindset that the 30 bags of cement were used to repair the issue where the accident took place. And if you look at the record at 151 to 152 and 367 to 368 and 370 to 371, the collapse where this took place wasn't where that cement was laid.
Oh, I see. So you mean part of the floor, there's one room and part of the floor had no bottom and the other part of the floor had a bottom? Is that what you're trying to say? I'm not quite sure.
No, I'm not being rhetorical, because no one knew. I mean, this is related to the fact that no one, certainly not my client, And I don't believe Joy had any idea that there was a subterranean basement.
Okay, which is
Below
why
a
I
portion
said,
of
why
floor.
don't you counsel? Which is why I said, why don't you answer the questions that were posed to your opposing counsel?
I'm going to
One,
answer
how
that,
was
and
this
then I have other
foreseeable?
points. That I
Don't,
wanna-
you know, in my opening remarks, I usually say, don't talk when the court's talking, get right to the facts, we know. And you know what? I should have said it this morning and I didn't, so I'm saying it now. Don't talk when I'm talking, or any of my colleagues.
I respectfully
You're doing
apologize.
it again. You're doing it again. So my question is for you. Why don't you answer the questions that were posed to your colleagues? One, why is this not foreseeable? Two, why wasn't there an inspection?
One, no one knew that there was a basement. There was no indication that there would be a basement. Two, the accident that took place was 7 months after Joy had taken possession of the property and had done the concrete repair. Three, where the concrete repair was done was not where the accident or the collapse took place. So there was no foreseeability to prevent against this type of fall by Mr. Senera, because no one had any idea that there was a gravity-related risk that could have happened in this case.
But counsel, even if there was not foreseeability at the beginning of the license, once the gaps occurred in the flooring that required so much cement to fill them, shouldn't that have made it foreseeable that something unusual was happening under the floor that required a responsible owner to hire an engineer to look and see what was happening? It seems to me that's the point at which the foreseeability certainly becomes most salient, and I don't understand why at that point your client didn't have some obligation to take a look.
Well, I'm not disagreeing with you on that, Your Honor, but I believe what they did is that they inspected the floor and they found surface cracks that didn't indicate that there was any subterranean basement, and then they did the repair on that. They still believe that this was gravel or sand underneath the
engineer's report showing an inspection. I don't recall that in the record. If they looked at it, that's not an inspection of the type we're asking about.
Your Honor, I'm at a disadvantage because my client's the one that gave the license in 2011 and hired Joy to essentially take over this property, and then subsequently they were going to demolish it.
So I have a question. This is
Yes,
Judge
sir.
Ryan. Your client owns the property where the collapse occurred, correct?
Correct. Yes,
Right.
that's
so
true.
that
One of my clients.
I'm sorry?
Just one of my clients.
Just one of your clients, all right? They own the property. So that my question is, in the record there, when did they purchase this property, and was there an inspection done at the time of the purchase? I mean, that would be, to me, explain, at least shed some light on foreseeability. Was that in the record? Because I didn't get to see that in the record.
No, Your Honor. What my client ended up buying this for investment purposes and to demolish
Well,
it.
that's not a good answer. That's no defense to the foreseeability. I mean, you get what you get, right?
Yeah,
So
that's true, Your Honor. I'm just saying that my client had no idea that there was a basement here. He did it cursory.
But that's the problem.
That goes to the
That's
factor
the
issue.
problem.
Yeah, that's the factor
An
issue.
inspection would have revealed it.
Right. When you buy, right. Even if you buy for investment purposes, you'd get some sort of inspection report telling you what's going on and what you're getting. I mean, all that would have been helpful to me to determine whether or not there's a factual issue. I didn't see that record.
Yes.
And it also doesn't change the fact that you owned it. You owned the building during that period.
That's correct, Your Honor. I believe the property was used as a parking lot prior to my client's purchase of this.
Doesn't matter what it was used as. You owned it, no inspection, holes in the floor, 30 bags, foreseeable.
So I'm going to just shift gears because I don't want to run out of all my time here.
Yes, you have 2 minutes left.
Okay, so just quickly, other than my client that owned the property, none of my other clients have anything to do with this case whatsoever, and I would rely on my brief for that. The accident took place in 2013, and all of my clients are either not-for-profits or not in ownership. They have nothing to do with this. They're not proper labor law defendants. The other point that I wanted to make before I run out of time is that Joy, who we third-partied in, was supposed to procure insurance for my client, failed to do that in the lower court, never addressed that breach of contract, and we should have been named as an additional insured, and we weren't. In addition, there is an indemnification agreement that my client should have been indemnified by Joy. That was never addressed by the court below, except to the fact on the appeal, there's an issue that's being raised that the provision violates General Obligations Law 5-322.1. I've made points in my brief of why that should not be applicable here, especially under the circumstances that my client gave this property to Joy with the understanding that it was going to be demolished by Joy thereafter, and it was Joy who prepared that agreement, not my client. So I know I'm almost out of time, but the last point that I would just want to make to you is under Labor Law 200, my client, after it bought the property and gave this license, had nothing to do with the property, had no supervision of the control or the methods or the means. It had nothing to do with anything here. So at the very best here, we have one client of mine who perhaps should remain in the case, but should be getting the benefit of insurance and indemnity from Joy.
Thank you.
Your Honor.
Thank you. Is it Ms. Rosen?
Yes, Your Honor. May it please the court, Kara Rosen on behalf of the plaintiff. So as we've seen here, the defendants are putting forth the argument that they can blindly, as owners of this property, begin a project wherein they're going to use this location for the storage of very heavy construction materials and equipment without any inspection whatsoever to determine the structural makeup of this building. There was no inspection. There was no engineer. They didn't even pull the certificate of occupancy to make some sort of attempt to find out what this structure was made of. There was zero attempt to make sure that this building was safe for the purposes for which they were going to be using it for. And the argument that they should be permitted to blindly ignore all of this is in direct contravention to the purpose of the labor law, which is to place ultimate responsibility on owners and general contractors to promote the safety of workers. That was completely ignored.
Would it be fair to say that you're saying that your client and the other workers were being used to test whether or not the floor was strong enough to support the work they were doing?
That's an interesting way of putting it. Yes, because there was absolutely no effort made to ensure that it was safe for them to do so. Clearly, the collapse of a floor brings this into the protections of Labor Law 240 sub 1. There's clearly issues as to whether this was foreseeable based on the holes and the gaping spaces in the floor. There's clear evidence based on photographs that there was a downward slope. There was exterior blocking on the outside of this building. There were clear ways for the defendants to become aware of this void underneath the location where they were going to be storing heavy materials. Clearly, carrying capacity should have been the first issue addressed in terms of safety.
Thank you. Any other questions? Any questions from the panel? I think we have your argument. Thank you, counsel.
The rest of my brief. Thank you, Your Honor.
Yes. Okay, we go back to you, counsel for Joy and 3170. You have 2 minutes.
Thank you, Your Honor. I would like to turn my attention to just 2 other issues, and that would be Labor Law 200 with respect to 3170 Webster, who was not the licensee. Again, remember, there's the owner of the building next door, and then Joy, its contractor. So with respect to 3170, they did not have any actual notice. There's no proof that they ever entered the property or that they knew that there was any kind of a defect or problem with the floor. There's no, so 3170, the owner of the property next door had no physical or a connection with the property. So I think that the 200 should be dismissed.
Didn't they hire the contractor who then used the building next door?
Yes.
Right.
But that.
Go ahead.
But that doesn't make them, they didn't direct and control and supervise Joy. They didn't direct, control, or supervise the plaintiff. They weren't actively involved in any of the work that was going on next door. So with respect to the 200 claim, that should be dismissed. May I then turn my attention?
Delegable duty to provide a safe workplace?
Your Honor, in order to provide a safe workplace, that you still need to have notice of a defect. Since this is a defective condition and not a means and methods of the work, there still has to be
And you claim
notice.
no notice where you conducted no inspection. Again, you can't not do what you need to do in order to safeguard your workers and then say, because I didn't do that, I'm not responsible.
Or because I didn't see what was in front of me, I didn't choose to see or ask. That doesn't give them lack of notice.
But this was not their location. I can understand if the accident happened at 3170, but it happened at 3160, which is not their location, and they didn't enter into the license. But I can see where the court is going with this. May I have my remaining time to talk about Joy and the insurance procurement?
You have 1 minute because you only had 2 for this. I'm giving you an extra minute.
Thank you very much, Your Honor. With respect to the insurance procurement clause, Joy, the defendants, Bedford, Webster, and the rest of the defendants didn't offer any proof in this record to establish there was a breach of contract to procure insurance. There's nothing in the record such as letters tendering the defense to either Joy or its insurance company. There's no certificates of insurance. There's no insurance policy. This is a completely undeveloped record with respect to the insurance procurement issue. With respect to, he didn't mention it, but they were also seeking contractual indemnity from Joy. But the only way Joy can be liable, of course, is through a written express contract. And this contract, this license, did not have language to the fullest, did not have the language, the saving provision to the fullest extent permitted by law. And in the event that the court finds that there is any negligence on the part of Bedford Webster, then that contractual indemnity clause would not take effect.
Thank you. Thank you, Ms. Hadukovich, Mr. Mazes, and Ms. Rosen.
Thank you.
Thank you, Your Honor. All.
Thank you.
The next case is Mishkin versus Andrea. Mr. Thomas.
Yes, I'm trying. Yes, good morning. May it please the court, William Thomas for appellant. Trying desperately to get my camera to work. Hopefully.
We see you.
Good. Okay. I would just start right in by directing the court to the letter at page 375.
So let me just say this. So Judge Hillerstein in the federal court did not reach the claims that are being raised here because Ms. Mishkin was precluded from requesting her fee in federal court.
You have
am I correct?
You're absolutely correct, Your Honor. That is indeed central to our position on this appeal. The point being that both Judge Hellerstein himself, repeatedly, in fact, and the Second Circuit expressly limited any possible fees recoverable by Ms. Mishkin to the services rendered pursuant to the liaison counsel appointment orders. There were actually 2 of them in federal court. That issue,
excuse me,
was made very clear.
Excuse me, am I correct that Judge Hellerstein specifically stated that your client was relegated to her remedies in state court?
Correct, Judge. That is absolutely correct. And that was at page 107 of the record. So in light of that, the idea that she should then have been precluded as a matter of res judicata really, I think, borders on the frivolous, if it is not in fact frivolous. And indeed, we would submit that this court held that argument frivolous about 20 some years ago in the Creative Bath decision, where the federal judge had expressly said, I am not reaching certain state court claims. And the plaintiff then attempted to pursue them in state court. Defendants argued that it was barred by res judicata. This court held that argument sanctionably frivolous. I submit that is precisely the argument that respondents made below to Judge Engoron, given that they had specifically argued to Judge Hellerstein that she should not be able to recover anything in federal court other than her liaison counsel service fees. It was particularly audacious of them, I think, to put it charitably, to then argue to Judge Angoran that no, she should have actually pursued these in federal court. And gosh, she's barred by collateral.
Thank you. I think we have your position. Mr. Visa.
Either way you'd like to pronounce it, Judge.
Well, I would like to know how you pronounce it.
I say Visa, but if you go back
okay,
to
so I got it right the first time.
Visa.
Visa. Why don't you?
Well, that's fine.
Why don't you go ahead?
We get to the heart of your question, Justice Renwick, and Justice Gessmer pointed it out also, what we call that private engagement comment from Judge Hellerstein. It's at 107 of the record. He said, if you have a claim of private engagement by counsel, I'm without supplementary jurisdiction. I dismiss it. She can pursue it if she wishes in state court. Great. But if you look at the previous paragraph, R106, like that claim, she never preserved it, she didn't pursue it, and she could have and should have. And Judge Hellerstein says if she wishes to complain about her legal error and how I restrict her work, she's free to do that, but should do it in a way that allows me to rule intelligently on an application within the parameters of my ruling and save the rest for appeal. So that comment, that unfortunate comment, did not leave her free to bring this state action for several reasons.
Are you saying we should disregard that comment you referred to as unfortunate?
Sure, it's an unfortunate comment by Judge Hellerstein, who did in fact—
no importance and no meaning, that we should just disregard it?
Because she had 3 appeals in federal court, she could very well have argued that Judge Hellerstein was incorrect in that regard. Because the gravamen of her claim is that she's such a great lawyer that her work benefited all the other plaintiffs. That is called a common benefit fee. That is something Judge Hellerstein has the jurisdiction to award and did award to other counsel in this particular case.
That may be, but Judge Hellerstein still made the decision to separate it. He separated that part to state court.
And even—
And she appealed that portion that he didn't. So why wasn't it preserved there for her to go to state court?
Even an erroneous ruling in the other jurisdiction can still trigger res judicata. So why is it that even assuming arguendo there was some leave to pursue the state law claim, how many ways do we have to knock out the state law claims? Let's start with the fact that there is no basis for an ex parte application under 306B. Leader is a triptych of cases from the Court of Appeals. It gives us a roadmap, and it doesn't justify the violation of due process to say, I'm going to file an action and keep it a secret. Man, that's good. I'm going to want to extend my 120 days. The trial court specifically said that she cannot use it, the extension of time to serve, to satisfy the condition subsequent of timely commencing the action. So statute of limitation knocks her out. That comment, and by the way, there's no basis in the record to refute Neil Mascolo's affirmation to the effect that he did not hire Michigan to do any work for us. And in 30 years at the bar, I've never been accused of a shameless fallacy, but in fact, Mascolo at page 442 of the record, paragraph 2, which is quoted in the brief, states he never relied on her to prepare any papers. She didn't do any work that we didn't do ourselves. The gravamen of the federal case, and then there's an issue that collateral estoppel will bar her on, is that Michigan could not recover fees in federal court because she failed to maintain contemporaneous billing records. That stays with her. We do have those contemporaneous records.
Counsel, this is Judge Owen, but didn't Judge Hellerstein remove the plaintiff from being liaison counsel, and then because all the attorneys pitched in and said, no, she's done a lot of work for us, she's done this, she's done that, she's done this, she's done that. So then Judge Hellerstein, based on that kind of movement, brought her back in as co-liaison, not lead counsel, but co-liaison for these litigation. In this action in Supreme Court, she's looking to recover funds for being lead counsel, not being liaison counsel, but lead counsel, doing the kind of work, or at least claiming that she did the work, that counsel went before Judge Hellerstein and said, no, she did all this, she did all this, she did all this. So I can't seem to reconcile those kind of discrepancies here to say that at this point in time, she's not entitled to at least go forward with her action and should be outright dismissed for failing to state a cause of action. Do you understand what do you follow what I'm saying?
Yes, Justice Owing, if I understand your question, there's a difference between doing such a good job as taking over de facto lead counsel. Right now, de facto, what does that tell you? It means it's unofficial. Oh, I was never appointed. I'd like to call myself that.
Right.
The ability to do work that all the other plaintiffs benefited from is called a common benefit. That common benefit fee was within Judge Hellerstein's power to award, and he did give it to another attorney in that same litigation that's cited in the brief. So the idea that she
wasn't the judge concerned about not passing on work done prior to the case ending up in federal court? I thought that was the reason why Judge Hellerstein did not want to address it and would only address fees and remuneration for work done once it was in federal court.
Well, I think the distinction, Justice Manzanet, is that Judge Hellerstein was saying, hey, if you think you have a claim that the other attorneys hired you on a per diem basis, essentially, right? Go to court for us, which she never did for us. If you think that's the case, then go ahead and bring that claim in.
I don't believe that's what the judge said, but that's clearly how you interpreted it.
Sure. And the private engagement issue is assuming there's a contract. Now, the letter to which Justice Oing referred, I'm sorry.
Counsel, you should wrap it up because you should finish that thought because I've given you extra time.
Thank you. The letter is not a contract. So she has no basis for an ex parte extension. The statute of limitations has run, and that's still a problem. And the idea that she could have gotten a common benefit fee was indeed decided in federal court. The other claims could have. Res judicata would close those out. In closing, I'd like to thank the court and Ms. Rojas and all the court staff for all the work and adjustments that must have been necessary for this. It makes it quite convenient for us to argue in this manner, and I appreciate it.
Well, that's very kind and thoughtful of you. Thank you for taking part in our virtual argument. And now I am back to you, Mr. Thomas. Sorry.
Rather than address counsel's many arguments, I would respectfully refer the court to our reply brief, which certainly does address all of those. I would very briefly address Justice Manzanet's concern about the time frames here. The key is work done, it's not so much about the when, Your Honor, as it is about the nature of the services. The liaison counsel appointment orders delineated the nature of the federal tasks for which Ms. Mishkin was exclusively entitled to seek compensation in federal court. We are seeking essentially compensation for pretty much everything else she did, which was quite extensive, as I think the court senses, in both state and federal court, outside the four square corners of the liaison counsel duties as delineated by Justice Hellerstein.
Thank you. Any other questions? Mr. Viz and Mr. Thomas, thank you both.
Thank you, Your Honors.
And our last case for argument is People versus Anonymous.
Good morning. Benjamin Rutkenbecker on behalf of Appellate. May it please the court. My client's sentence of 8 years incarceration to be followed by 5 years post-release supervision is excessive and should be reduced to 5 years incarceration plus 2.5 years post-release supervision. A 5-year prison sentence both amply penalizes my client for his limited role in what we do not dispute was a serious offense and fully considers the person who stood before the court, a father of 3 young children.
Can I ask you a question? was the acquittal on the other case as a result of something that your client did?
Your Honor, my client did not testify on that second case, but I would like to address...
No, that's not what I mean. There was a hung jury. I'm sorry, I phrased the question wrong. Let me rephrase it. Was there anything with regard to the first hung jury that was attributable to your client?
No, Your Honor, not at all. And the prosecution mentioned at sentencing that they believed my client testified truthfully and accurately at the first trial.
So he essentially complied with the deal, right? The cooperation agreement was there. I don't think the cooperation agreement called for a second retrial. I mean, it just said you're going to cooperate and we'll give you, this is the deal you're going to have. And he cooperated, right?
That is correct, Your Honor. And
I think the record indicates, at least my understanding, is he didn't want to go to the second one because he goes, wait a minute, if I go to the second one, people are going to know in prison that I'm cooperating with you and I'm going to be in trouble.
That is exactly correct, Your Honor. And it's worth emphasizing that, as Your Honors are noting, there was one jury vote for acquittal. That is the difference between a 2-year sentence here under the cooperation agreement and the 8-year sentence that my client ultimately got. And even before the court at sentencing, he was eligible for the 5-year minimum, which would have been more than enough here. And I would just like to further point Your Honor's attention to the sentence of a co-defendant, which the court could not consider at the time of sentencing, of course, who the prosecution does not even attempt to argue was not similarly situated in terms of his role in the offense. And that co-defendant received a 3.5-year sentence. He was not only allowed to plead to a lesser charge, but also to the minimum to that offense. And the prosecution's only justification for this disparity is that that co-defendant was a true first-time offender, although it should be noted that that co-defendant had also subsequently committed another felony that he was sentenced concurrently and in consideration of as well. And the prosecution also concedes my client's, quote, petty criminal history, which consisted only of a YO and misdemeanor marijuana convictions. If there are no further questions as to the sentence, I'll just turn briefly to the... Oh.
Go ahead.
I would just turn briefly to the waiver. The purported waiver is invalid here. The oral colloquy was insufficient and cannot be saved by the written waiver because the record does not demonstrate that my client read and let alone understood the waiver. And if there are no further questions on that, I'll yield the remainder of my time for rebuttal.
Thank you. Mr. Yetter?
Thank you, Your Honor, and may it please the court. I'll pick up, I guess, first with the waiver of appeal. As we argued in the briefing, this was a knowing, voluntary, and intelligent waiver of appeal. I think if you read the plea minutes around pages 8 to 9, you'll see, one, that Justice Obis separated his discussion of trial rights that were automatically being forfeited as a result of the plea from the defendant's waiver of appeal, which he made clear was in addition to those rights and a condition of this agreement. And we think under the controlling case law that even if there was some imprecision in the wording that Justice Obis used.
Counsel, this is Judge Owen. I'm concerned about the cooperation agreement because I'm looking at the cooperation agreement, at least the minutes here on page 3, right, of the record here from the October 14, 2016 transcript. And it basically says, we have on the table a cooperation agreement wherein the defendant would agree to plead guilty, blah, blah, blah. Then it goes, if he cooperates in the matter of Devon Putton, which is pending before the court and gives truthful testimony and otherwise complies with the terms of the cooperation agreement, he will be permitted to withdraw his plea, and goes on, and that's the end of it. I don't see in this record here where the defendant did not honor this agreement. He testified at that trial. You got a hung jury. And this cooperation agreement doesn't have the tagline and any other further proceedings that he has to continue to cooperate. It just says the one proceeding that's pending before the court. The fact that you got a hung jury, that's not his fault. So that now you're saying that you're not going to get the sentence that's promised under the cooperation agreement because you didn't testify at the second trial, at the retrial. But there's nothing in here, according to what I'm reading, unless I'm missing totally, I'm reading the wrong transcript. There's nothing in here that says, and plus any other retrial proceedings you got to cooperate to. So how do we hold the defendant to the second, for him not going to testify at the second retrial when he clearly, and even the prosecutor said, you know what, he did what he had to do on the first time, at the first go around. We just didn't get it, just got a hung jury. So how do we hold him? How do we say he did, how do we say we can't honor that plea agreement, that he gets the whatever 2 years or whatever? Can you explain it?
I can attempt to, Your Honor.
Okay.
I think one thing before I answer your factual point is that it is undisputed on this appeal that the defendant did in fact violate the cooperation agreement. So that's, defendant doesn't argue that by not fully complying in any proceeding in which he was called to testify related to the murder case.
That's not what this says, though.
Your
that's
Honor,
that's not what the record of the minutes say.
Your Honor, I noted in footnote 3 on page 4 of my brief that we would be happy to provide a copy of the cooperation agreement to the court, and I am still willing to do so.
Then if counsel, if you take that position, then this is the problem. Then the waiver can't be valid, because if he's saying, if the statement on the record is one thing, the written plea agreement says something else, and then he does a waiver of appeal. The problem that I have is that what he's representing in court and what he signed, those are two different things. And I don't know if that's fair.
Well,
and I just have to add, I just want to add one thing to that question, which is something you said. You know, the word any, it says truthfully testified in any proceeding. That could be one or more, and he certainly did testify in one proceeding fully and completely. So the ambiguity of your what you say he didn't testify to certainly seems like no one disputes that he testified truthfully in the proceeding he was involved in.
No, Your Honor, I do not disagree that he, and I believe the prosecutor stated at sentencing that he did testify truthfully.
The word any is the one I was really talking about. Any.
So basically, he's
testified in any proceeding. He did testify in any could mean the one he did, and he did.
I mean, in essence, he's being punished an additional 3.5 years because your office could not secure a conviction. How is that fair?
Your Honor, respectfully, I know that some of the argument by the trial prosecutor at the sentencing proceeding related to the sentence itself was premised on the failure to comply with the cooperation agreement. But I will say that Justice Obis was careful, and he imposed a sentence that was not premised on the failure to comply. He said it explicitly in the sentencing proceedings. He said it was based upon the defendant's conduct in this case. So I agree that this defendant in the first trial appeared and testified truthfully. And then the record bears out that there were issues with respect to the second trial. He ended up not testifying. And I know there's been a lot of questioning about the compliance or not with the cooperation agreement. And I just feel I need to say that he undisputedly violated the cooperation agreement.
Counsel, this does not bode well for the people for future cooperation agreements, I have to tell you. If you can be sandbagged in this way.
Your Honor, I guess I understand your position, but I don't think the record actually bears out any sandbagging. Again, I am happy to submit, as I noted in the brief, the cooperation agreement, but I just respectfully, I understand your position, but I don't think the record bears out that this defendant was sandbagged or misled. I don't think.
Are you saying that there's sensitive information that wasn't revealed that we don't know that surrounds this?
I'm just saying the
testimony.
The cooperation agreement is not in the current judgment role that I believe your honors have up at the court.
But you said, I'm a little confused by your argument. You said that Justice Obis didn't conclude the defendant did not testify truthfully, which would mean he didn't violate, which would mean that he complied with the cooperation agreement. but then why wouldn't Judge Obis be bound by the promise in the cooperation agreement? I have trouble with your argument.
No, my understanding is that the cooperation agreement was not just limited to did he give truthful testimony. I don't think he was found in violation of the cooperation agreement for failing to give truthful testimony. It appears that the violation was premised on his failure to testify in the retrial of Devin Putnam. So I don't think there's any allegation that he gave untruthful testimony. I think the violation was, I'm sorry, Your Honor.
So what is the exact language that you claim required that he testify anytime the people wanted him to in order to get the benefit of the cooperation agreement?
Right, that is the
What is
language.
the specific language? Since you didn't give it to us in your record.
Well, I don't think we didn't prepare the record, and I believe Supreme Court sent it up. I can pull it up.
But it's your obligation to make sure that we have what we need to decide the case.
Right, Your Honor. I understand that, and I offered to send it up with my brief. We didn't hear from the court. I'm happy to send the cooperation agreement to you for your consideration. But again, I didn't. I guess it was under.
Counsel, what is the specific language in the cooperation agreement that you are relying on, since we don't have it in front of us?
If you give me a moment, I'm happy to pull it up. I'm sorry, Your Honor. I don't have it. Sorry, I'm having.
So can I ask a question? So he doesn't, according to your argument, he violates the agreement by failing to testify a second time. Had the jury come back with an acquittal on the first trial, he would be serving 2 years. Am I right? He would have complied with his agreement, correct?
If he had testified truthfully and
Which he did. There's no question that he testified truthfully, or is that in question now too?
No. I think I've represented. There's no allegation that his testimony was untruthful.
Precisely. So follow me. If there had been an acquittal on the first trial, he would have been sentenced to the 2 years because he fully cooperated with the agreement, correct?
Your Honor, yes, if that's how it.
Right. So he basically is punished because there was a hung jury, and again, your office was unable to secure a conviction. So he pays the price for that.
I believe, Your Honor, I wouldn't agree with that characterization, Your Honor. He was found not to fully comply with the cooperation agreement. And Justice Gesmer, to answer your question, the agreement says that the defendant, I know is anonymous, agrees to testify truthfully as a witness regarding the murder of Donald Cox in any grand jury proceedings, pretrial hearings, trials, or other proceedings at which he is requested by the office to testify. That's the language that I'm relying on.
Thank you.
Thank you.
And your rebuttal, counsel, Mr. Yetter, is it?
Mr.
I'm sorry,
Rutgenbecker, yes.
Rutgenbecker, you were Mr. Yetter. Sorry.
Thank you, Your Honor. Unless there are any questions for me.
I do. According to the briefs, the concern of your client was that he would be found out and be in mortal danger in prison. Am I right?
That's correct, Your Honor.
Was that fear communicated to the people and to the court as a reason why this young man did not want to do the do-over?
It was, Your Honor, and even Judge Hayes, who presided over the second trial and who attempted to procure my client's testimony with ultimately contempt, recognized that my client's fears were truthful and that was in fact why he didn't testify.
Thank you.
Well, I have one. I'm sorry. I have one question, counsel. The prosecution said that Justice Obis imposed the 8-year sentence based on the facts of the crimes charged in this case, and not based on the fact that the cooperation agreement wasn't fulfilled by the defendant. Is that accurate?
Your Honor, I appreciate that that was Judge Obis's view, but I just cannot agree with that. And I think Your Honors can all appreciate the predicament that my client was facing. So if there are no further questions,
okay, thank you.
Thank you, Mr. Yetter. Thank you, Mr. Rutkin-Becker. Have a good weekend.
Thank you, Your Honors.
That concludes, that was our last argument, and that concludes oral arguments for today. Court is adjourned.